Hi, I'm Dr. Sam King, Medicolegal Consultant with Medical Protection. Today, we are talking about what to expect when the coroner takes jurisdiction. It's about the coronial process and the uncomfortable bits for clinicians. And most of us rarely have any dealings with the coroner, so when they need to provide a coroner's report or become an interested party at an inquest, it can be a very anxious time. And today we're going to demystify that process with you. I'm joined today by Dr. Tim Cookson, one of my fellow medico-legal consultants, and also we have the privilege of having Mr. Adam Holloway with us, who's one of the partners at Watton & Carney, our panel law firm. Hi guys, welcome to the podcast.
Hi Sam.
Thanks, Sam.
So there are three purposes of a coronial inquiry. Firstly is to establish that a person has died, when the person died and the circumstances of the death and cause of death, if it's unknown. The second purpose is that the coroner can make recommendations or comments in order to reduce the chances of further deaths in similar circumstances. The coroner has no powers to ensure that their recommendations are carried out, but they certainly do make a lot of recommendations. And the other purpose is to determine whether public interest would be served by referring the case to other investigating authorities, for example, Waka Kotahi, the Land Transport Agency. Now, obviously, you'll all realise that most deaths are not reported to the coroner. And in those situations where the death is expected, the cause of death is known, and there are no suspicious circumstances, the coroner would not take jurisdiction. It's not uncommon for MPS to assist members with coroner's reports where it appears the coroner has only taken jurisdiction because of the clinician has not been certain of the cause of death in an elderly multi-comorbid patient. Tim, I just thought I'd ask this of you. What do you suggest doctors do in that situation where they know the most likely cause of death but can't be 100% certain?
Yeah, look, it is a really tough decision for a clinician to make because, on the one hand, you kind of want to be really accurate and make sure that if you're writing something on the death certificate that it is absolutely right. But on the other hand, do you really need to go through that coronial process to get to that point? And the kind of question that I always had in mind was, am I surprised by this death? And if the answer to the question was no, I'm not at all surprised, then that led me to believe that actually this really wasn't likely to need to involve the coroner unless you became aware of something that had occurred that shouldn't have occurred, like someone had been dispensed 10 times as much morphine as what you thought you'd been prescribing. So even though you may not have the exact answer, I think if you've got some significant comorbidities like ischemic heart disease and the circumstances of the death were consistent with someone dying from ischemic heart disease, yeah, look, that's absolutely fine to put that in, even if you're not absolutely certain. And remember, of course, that sometimes even when a post-mortem is done, there is often still no absolute answer as to what might have been the cause of death. So, thinking, oh, well, I'll get the coroner involved, there'll be a post-mortem, there'll be an absolute answer. Actually, that may not be the result. But if you're worried about what might have happened, if you think there's stuff going on that you think ought not to have happened, and then certainly that would be a time to think about getting the coroner involved. And the good thing about it is that the duty coroners are actually quite happy to hear from us. And they'd much rather hear from us, have a discussion about what's going on. And in fact, we've sometimes had doctors who've rung us back and said, oh, look, the duty coroner is really keen for me to write the death certificate. I'm still not quite sure if I should, but, they're really keen for me to do it. So I think if the duty coroner says, yes, it's okay for you to go ahead with the death certificate, you can take that at face value and rely on that advice.
Thanks for that. Adam, when must doctors report to the death to the coroner?
So the coroner's jurisdiction has its own piece of legislation, and that sets out the circumstances when deaths have to be reported in, and then the coroner will always take jurisdiction in those circumstances. So the first is if the cause of death is unknown or was self-inflicted, unnatural, or violent. The second is where the death appears to have been the result of a medical procedure that was medically unexpected. So it's important to remember that there is that other component, that there will be occasions where a patient may die, but that is not unexpected consequence of what was going on. A death under anaesthetic that was medically unexpected, a death related to pregnancy or childbirth, or a death in official custody or care. And those are defined terms, but think prison, someone in detention with police, but probably of most relevance to members would be circumstances where someone is under the Mental Health Act and dies. Those are all deaths that must then be reported on to the coroner.
Thanks for that, Adam. Tim, as you're aware, sometimes the police turn up on the doctor's door after a death in the community, and that could be, honestly, any time of day or night. I still remember being woken at 2:30 in the morning by the police pounding on my door because a patient had passed away. What would you advise doctors to do in that situation?
Run. Definitely run. There's no other option. They should just go for it. Well, they can, before they run, maybe have a little bit of a chat with the police about what the purpose of their visit is. So find out why the police have actually called at that time. And if it turns out that they're thinking there's a crime has been committed, then obviously, yes, you have some sort of obligation to try and assist the police at that point. But that doesn't mean that you have to do it on your own. And so MPS, we do have people available 24 hours. And if you're in that situation where you feel you're going to be vulnerable, don't feel forced to talk to the police without having some assistance, and we can certainly provide that. More commonly, it's just going to be that they're assisting the coroner and they're wanting to make some preliminary inquiries, and they don't have to call at 2 a.m. really to do that, but it's just that they didn't have much to do on the shift at that time and felt that they could occupy that moment. You can ask for any questions to be provided in writing, which means that you don't have to answer questions verbally on the spot. And if it really turns out that it's only for the coroner that they're inquiring, they're not worried that there's been a crime committed, then you can say something like, look, I'll be very happy to answer the coroner when they write to me requesting a report. Is it okay if we leave it until then? And often the police will accept that. But it does vary throughout the country. There are some areas where the police take a much more active role than in other areas.
I think that's all very good advice. I mean, essentially, I would say slow the process down unless there's a reason why it needs to be urgent. And it'll be urgent in two ways, I guess. One is if the police are simply wanting your assistance, say, to get access to some health information that might assist them with their inquiries, as you said, Tim, into a crime, or to try and locate someone, for example. And then you are simply in that situation of providing assistance to the police in a situation that has some urgency about it. Or, very, very rarely, the focus might be on you. And we can come to talk about that in a moment. But almost all of the time, there won't be a need for urgency, and there are polite and reasonable ways to just take a step back and try and slow that process down. So you do have the opportunity to get some advice, some support, some assistance about how you want to engage with that coronial or police process.
There are times, Adam, aren't there, though, where the police are perhaps representing the coroner, but they are also investigating a potential crime. And so let's just say the police come and you've suddenly become this person of interest. And I digress a little bit from the coronial process, but what would you do if the police are wanting to take you down to the station and ask you to surrender your phone? And I, that was a call that I took one evening from a very distressed member who had been not arrested and charged by the police, but essentially they had door-knocked him, advised him about a very serious matter, and asked the doctor to escort them down to the station and to surrender his phone. And I guess most of us in that situation feel, one, shocked and somewhat anxious, and we want to cooperate with the police. And so he did comply. So when he called me, the member was actually in the police car already. So what would you say to members in terms of, you talk about slowing the process down, how would you advise our members to do that?
Well, should that ever happen to a member, and I hope it's not something that happens often because it would be very distressing. I would ask the police if I were under arrest. And if the answer is no, then I would say, look, thanks for dropping by. I'm going to go and have a conversation with my lawyer, and you feel free to leave me your business card. I'll be back in touch in due course. So the police can't compel you to go down to the police station or make a statement. They can, if they have cause, arrest people, and then you're under arrest. And if that happens, say nothing and ask to speak to a lawyer. But police also can't require you to make a statement. So if you're getting pressure to do that in a time frame that's unseemly, again, slow the process down. Say, I want to get some advice about this. Leave me your number and contact details. I'm very happy to get back in touch with you once I've done that. It'll be tomorrow or the next day, and we can pick it up there. Sometimes what might happen is, with the assistance of MPS or us as the lawyers, we might approach police and say, this person doesn't want to go and give an oral statement. But if you've got particular questions, then by all means send us an email and we'll address those in writing if we feel it's appropriate. On other occasions, it might be fine to go and talk to police and give an oral statement. It depends on the circumstances, but certainly there are cases where we might want to go along too and sit next to the member, be there and be ready to call a halt to things if they take an unexpected turn.
Mm.
Great. So look, my take-home message from this podcast already is, if questioned, just say, am I under arrest? I'm going to remember that at 3 a.m.
Actually, at 2:30 in the morning, the police got nothing out of me because I was barely awake and couldn't put 2 sentences together, so they had to leave. So let's move on and think about more serious matters, about giving medical certificates for cause of death. And we're often asked about the requirements to examine the deceased prior to completing the death certificate and cremation certificate. And up until the pandemic, we've always interpreted the word examine to mean a physical in-person examination. When a person dies and the death isn't sudden, unexplained or suspicious, or meets any of the other criteria for referral to the coroner, the certifying practitioner who attended the person during their illness, so you had to have seen them during their last illness, is required to give a medical certificate cause of death immediately after learning of the person's death. And if they are satisfied that the person's death was a natural consequence of the illness, and in that situation we are not required to view the body. But if it's another health practitioner, let's just say you're a locum, one of the GP's patients has passed away, and you're asked to certify the patient's death, but you have never met the patient, then different rules apply. So under the Burial, Cremation and Cremations Act, or the Act, it requires the practitioner to have regard for the medical records excuse me, relating to the person concerned from the health practitioner who last attended the person's last illness, have regard to the circumstances of the person's death and examine the person's body. And that really now means that you do need to attend and physically examine the body. Sorry, Tim.
In practical terms, though, for example, for GPs, what many practitioners do is, if someone's going to be away on leave for 2 or 3 weeks and they know they've got someone who's terminally ill and likely to die, and they've got someone who's going to be covering their practice, they may well arrange for that doctor to visit that patient. And so they've then fulfilled the requirements that they cared for them during their last illness, and therefore they don't have to go and see the body and do those other bits that would otherwise be required.
No, that's right. And that's certainly a very practical way around it. Let's move on and talk about inquests. When the coroner takes jurisdiction, they can require a doctor who attended the patient before death to provide a report. And many of you will have received a letter from the coroner requiring a report. The coroner has a standard set of questions that are asked, usually around the last consultation, if the patient was under the Mental Health Act. But the coroner may have more targeted questions about a particular patient. We at Medical Protection assist our members with coroner's reports, I think, on a daily basis. And the report is essentially a factual account of the care given to the patient and should be accurate and clinical. I often explain it as setting out the care provided as though presenting to a clinical colleague. I know that many of our members prefer to cut and paste the clinical notes and call that a coroner's report. Unfortunately, that isn't what the coroner needs. You have to remember that the coroner is a lawyer and has no clinical background, and it's hard enough for some of us to understand our own notes, let alone someone who's not a doctor to be able to decipher them. So you do need to write it out as a narrative. The difference between obviously writing something as though for a colleague and the coroner is that we do need to explain our terminology so that any three-letter acronyms or difficult medical terms are explained in lay language as well.
Sam, sometimes you do have doctors who are a bit reluctant to go through that process. And what I sometimes then suggest to them is that they just imagine themselves standing up in front of the coroner's court and reading out what they propose to submit as a report, with the coroner there, with the family there, with the lawyers from both sides there. And do they really think that that'll be a professional look for them to produce that? And most are convinced.
Most are convinced. Yeah. No, that's right. And I know that it's been a common issue for GPs in particular about the time required to write a coroner's report. But as you will all know now, we are entitled to charge for that service, and that helps to take some of the pain away. So coroners don't criticise the clinician's care provided as such, but we do know there are some medical legal risks to clinicians in the coronial process. Tim, what would you say the risks are?
Well, if for any reason the coroner does have concerns about the quality of the care that was provided by the doctor, and particularly if the substandard care might have contributed to the death, then they do want to look further to see, get clarification on that point. Coroners can ask for experts themselves to look at the evidence. They don't tend to do that very frequently, and these days the coroner is much more likely to say, look, I've got an unexplained question here that's medically related. I'm going to send this off to the Health and Disability Commissioner and get them to examine it. Or if there's something, and this must be pretty uncommon, where they think that the clinician's personal conduct might have been very unusual, the Medical Council might get involved there. But the biggest risk is really going to the Health and Disability Commissioner. And certainly if the HDC receives a referral from the coroner, they're going to take that very seriously. So it would be very unlikely for it not to be an investigation. And as we know, investigations are time-consuming and challenging for the member. So, it's really important, isn't it, for your report to make it really clear to the coroner exactly what happened and why, so that they don't have unanswered questions in their heads.
So one of the other issues, Tim, which can arise, and I agree with what you've just said, is that while I think you're right that coroners are slow to criticise, it is certainly within the coroner's jurisdiction to make what are called formal adverse comments. And so if at the end of a coronial inquiry, a coroner thinks that a clinician has made a wrong call and made a decision that didn't really meet the expected standard of care, and that decision played some part in the sequence of events that led to a death, then the clinician can be subject to an adverse comment. And that has issues around people's professional reputations, how they feel about what happened, and it can be quite meaningful for members to try and avoid that outcome if it's fair to do so. And then springboarding off an adverse comment, either the coroner might refer for further investigation if what happened was a severe error, or it can just be enough of a prompt to the family of the deceased person to make their own HDC complaint. So there is that other element of risk.
And certainly we've seen that situation with it. And in fact, to be fair, the coroners then will usually write back to the practitioner, won't they, and say, I'm proposing to make an adverse comment or whatever it is. Do you have anything further to say on that? So there's often a second chance before the final report is written.
Yes, there will always be that opportunity to consider and provide submissions in response to a proposed adverse comment. But that question you've asked is probably a good opportunity to take a step back and just give a bit of an overview about what the process looks like. So if I'm instructed as a lawyer to assist one of your members, the explanation I always give is along these lines. So a death is referred to the coroner, and as we've discussed, not all deaths are, but when a death is referred to the coroner has to undertake an inquiry, the outcome of which is a set of findings. And those findings will say who died, how they died, when they died, the circumstances of that death, and whether there are any recommendations that ought to be made to try and reduce the likelihood of a similar death in the future. So that's the overall process that gets kicked off. And it's what we call an inquisitorial process. So the coroner is in charge of calling for evidence and information, contacting people to say, I need to know something from you to try and feed into my overall inquiry. And once the coroner has completed that investigation process, there'll be a set of findings that are produced. As part of the inquiry, a coroner can either choose to, or in some cases where the right legal triggers are hit, a coroner must hold an inquest. And an inquest is a tool that for gathering further information in a particular way to feed into an inquiry. So the inquest is where a coroner will call people into a courtroom to give what we call oral evidence in a witness box, having taken an oath to promise to tell the truth. And how members interact with coroners' inquiries, they can either just be what we call witnesses of fact, so they can be asked to give a report, and if the whole inquiry ends up just being a written process, then that will be taken into account. Or they might be called to give their evidence at an inquest if the coroner thinks that there's something more than just a written process is required. If, though, the coroner thinks that that person might be vulnerable to being criticised or have one of those adverse comments made about them, then they'll become an interested party, which gives them more procedural rights to be involved in the process. And as you mentioned, Tim, it means that if there is going to be a criticism made, they'll always be shown that in draft first and given the opportunity to comment. So, witness of fact, interested party if you're in potential trouble, and then occasionally we'll be instructed for members who are being asked to give expert evidence. So they weren't involved at all in the clinical care, but because of their expertise, the coroner has asked them to come along to an inquest, say, and provide their opinion about what they think went wrong in this case.
And it's not uncommon, isn't it, Adam, where a clinician's a witness of fact, but they're also being asked questions as though they are an expert.
Oh, look, that can certainly happen. So sometimes members might be approached as a true expert, tapped on the shoulder to say, "Can you read the file and give me an opinion about this?" But the reality is that clinicians are experts. They've all studied to be good at what they do, and because of the nature of a coroner's inquiry and inquests, it's not at all uncommon for a coroner to ask a witness for their opinion as opposed to just what they can remember happened. It's perhaps a good time to also just quickly cover off the sort of help that we give members when we do become involved in coroners' matters. And for me, it has partly a pastoral element. a member who's being required to come and give evidence at an inquest is not uncommonly a bit anxious about that. It's a very foreign environment. Perhaps they've never been to court before. It would be like me walking into an operating room and not knowing where to stand or what to do to keep out of everyone's way. So there's help we can provide as lawyers in terms of just making sure people know what to expect, that they're ready to answer questions, that they know what sort of questions they might get asked, to intervene if the questioning becomes unfair, stand up and say, I object, to manage some of that potential unfair media reporting, or perhaps seek an order from the court that their name not be published. So there's a component that is really just helping make the process be as easy as we can make it for the member. And then the sort of sharper edge for people who are interested parties, who are vulnerable to criticism, we will help bring out their evidence and also test the evidence of other people participating in the process to try, if we can, to ensure that the right facts get found, that the coroner doesn't take a wrong turn and misunderstand something which would lead them to make an adverse comment that's not deserved. And so that's the other element that we become involved in when we are assisting members with inquiries and inquests.
And that pastoral care bit, I think, is particularly important, is that you and I, Adam, were involved in quite a lengthy coroner's case down in Queenstown of a young man who'd committed suicide, and the family were particularly bent on finding the doctors guilty of having, directly led to his suicide. And it was my impression that the inquest, one of the main reasons why it was actually held was because the family were so insistent that a public inquiry was held, as opposed to what often happens is the coroner making a decision on the papers where there's no public involvement whatsoever. And the process was really quite adversarial, and the family were really, they really wanted blood. And so having your expertise there to help protect our members was incredibly useful.
Yeah, and that's not an uncommon scenario where you have families who it might be driven by grief or guilt, come to a coroner's inquest with a lot of emotion and want to, after the fact, do right by their loved one by asking the tough questions as they see it, or trying to demonstrate that some person, perhaps a clinician, is to blame for the outcome. And there is good work we can do in helping to manage those situations, and also just being there with the member. I mean, we can't stop it from being tough sometimes, but it's good to have an ally in the room. And I don't want to leave listeners with the impression that it's always miserable. I think coroners and the best coroners, as well as what the legislation asks them to do, find out how someone died, and will also bring a therapeutic lens to it and see if they can run their process in the way where the family of the deceased person comes out the other end even just a little bit healed by it. And I've had the privilege of being in inquests where that outcome has been spectacular, where we've gone from very angry families asking tough questions through the process of explaining how hard everyone tried to keep their loved one alive, to at the end a speech volunteered from the public seating about how much respect they had for the clinicians and the evidence that they gave, and hugs all round. So it can be therapeutic. We do our best, but sometimes our job is to protect members from what can be quite uncomfortable.
And one of the things that sometimes occurs too is that the family in that process see how much of a a huge impact the death has had on the clinicians as well. And they seem to have kind of had that belief that they've gone off and their lives have continued, unchanged. But in fact, often at the time of the inquest, it's painfully apparent the impact that it's had on those clinicians. And that's often part of the healing process for the family too, isn't it, realising?
Yeah, that's right.
Thanks, Adam and Tim. Tim, we often talk to members around being witnesses in the coroner's situation. Can we touch just briefly on expert witnesses? What advice would you give to clinicians who are asked for an expert opinion?
We could probably do a whole podcast on that, really, couldn't
I'm sure we could.
Sam, thank you very much for saying, can we cover it briefly?
It's all right. I'll ask Adam as well.
Yeah. I guess there are a number of key principles. The first is that you've got to be sure that you really are an expert in that field. So you've got to have sufficient knowledge about it. And it's also got to be sufficiently recent. So just because you used to do a certain type of surgery 30 years ago does not make you an expert in that anymore. So think about those aspects and don't be afraid to say, no, look, I don't think I'm the right person because my expertise doesn't cover that area. And you also want to be, not just have knowledge of it, but to have been doing the things or been involved in the kind of things that you're going to be asked to be an expert on. You've got to make sure that there's no conflict of interest for you. So if it turns out that you're being asked to be an expert witness, but actually you cared for that particular person relatively recently, then that might make you ineligible to be a true expert witness. Because, of course, even though an expert witness may be called by either side, they're not actually there to support either side. And the role of the expert is really to inform the coroner and to help assist the coroner understand the complexities of whatever technical issue that it is. You're not there to push one side or the other, irrespective of whom you're called by. And you'll have written a report, you'll be asked to read that, and then there'll be questions asked around that. And it's best to do several things. One is to think carefully about the question before you answer it. And it's fine to say, look, I'd like to just refer to my report before I answer it. So again, buying yourself time. And then make your response, reasonably brief. Don't go on and on. If the person the lawyer who's asked the question wants more information, they'll kind of know that anyway, and they'll start leading on with questions at a greater depth. And remember that if you have strayed beyond your area of expertise in what you've said, the lawyers are going to pick that up, and you may well get exposed for that over-enthusiasm on your part.
Thanks, Tim. Adam, do you have anything you'd like to add?
Oh, look, not much. As was said, there's a whole discussion that can be had about the art of being a good expert, and there are two sides to that. One is deciding that you're happy to take on an instruction, and Tim's touched on some important things there, being comfortable that you're sufficiently independent and have the right expertise, and then preparing your report. And so what goes into that process is being very familiar with the facts that you're being asked to comment on. Make sure you've read the file in detail, stick to your expertise, reason out the opinions that you're giving. So if ultimately you're giving an opinion like, and I think therefore that it was the missed antipsychotic medication that was the major factor in this person's distress, you need to provide the reasons for that. Once you're then giving that report in evidence, if you are in fact called to do that orally in court, some of what Tim then segued into is, how do I deal with cross-examination? So when someone's trying to challenge my opinion, what are the right skills and tools about engaging in that question and answer process without being tripped up or led astray? And it's unlikely you'll be called to do that sort of job without having an interaction with a lawyer. Either MPS will be assisting you or whoever else has asked you to prepare the report. So just make sure you ask for time with that lawyer have that discussion and say, look, I want to spend a bit of time with you to talk through what cross-examination is going to likely be like, and how I should deal with that process if it's one that's unfamiliar to you.
Of course, as an expert witness, you don't have the right to be represented by a lawyer, do you? So you may be called by a lawyer, you may receive advice from them, but you're not represented by that lawyer. Is that correct?
So you're not a party. Yeah. And if the coroner is calling you, then usually the coroner would have what's called counsel assisting. So a lawyer who is assisting the coroner, and that person will be the person who is calling you forward to give your evidence, and they ought to be available to you for a chat. If not, call MPS. If one of the parties, the interested parties, is calling you, so for example, a clinician has asked for your opinion because what you believe is favourable to their cause, again, it's likely that they'll be represented by a lawyer. That lawyer will be the person calling you forward to give your evidence, and they'll be available to you to have that discussion.
That's great. I agree that perhaps in the future we might have a podcast dedicated to how to be an expert witness. So that was a look at the coronial process. Thank you for listening to this podcast, and thank you, Tim and Adam, for joining me today. We hope it's been really helpful for you, and we look forward to catching up with you in our next podcast. If you like the Medical Protection Podcast, please subscribe and leave a review. We'll see you again.